Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's subscriber to our YouTube channel sent an excellent question in, and it's regarding special needs trust. And this is a very, very important subject matter. We have a lot of clients that we assist with creating special needs trust, and it's rules of engagement, and there's a lot of strategies around protecting assets for our special needs loved ones, okay? Today's question is, hey Patrick, what are some helpful strategies for our loved one who has special needs? And so folks, I took some notes here. Numero uno, if you have a loved one with special needs, first and foremost, you want to assess and evaluate their level of disability. If it's fairly severe and they're not going to be able to take care of themselves in the future, if their parents get hit by the proverbial bus of life, then folks, you need to create, in my opinion, from my experience, a third-party supplemental needs trust. And that could be a standalone third-party supplemental needs trust, or have your estate elder law attorney, when they're creating your trust, bill and marry the parents' trust. They can create a sub-trust within your trust, referred to it as a third-party supplemental needs trust. Folks, I have other videos on this as well. What is the difference between a first-party versus a third-party supplemental needs trust? And you can watch those videos as well. The second piece to that, think of your trust like a metaphorical treasure chest, okay? You want to get your assets in there. So it's important to say in your estate plan, if you own a home, or say your IRA, 401k, whatever it may be, or a big bank account, or even a life insurance policy, you want to name not your special needs child directly or personally. If it's little Johnny or Mary, you name their trust. You name specifically the trustee of their trust as the beneficiary, because the trustee of their trust job is to receive that money and manage that money prudently, wisely, in the best interest for your special needs child. The special needs child can never be the trustee. The money can never be paid to them directly, because that will disqualify them and make them ineligible for their government benefits, okay? Because now they have private paid money. The government's position is like, well, you don't need government funds at this time because you just came into a windfall, an inheritance here. Or if you want to put it in that first party special needs trust, you can do that, but government's going to be paid back when you pass away. So hence the reason why the importance of creating that third party special needs trust when you're alive and well, all right? Very, very important. And you got to fund the assets. That's important. That's step 2 of our process. Make sure they're titled to the special needs trust for your special needs child. Make sure it goes to the trust, not them personally, okay? Third pointer right here, folks, is pick your trustee wisely. Pick someone who you trust unconditionally, someone who you feel is suitable who can manage the money for the benefit of your special needs child, to make sure it's safe for them, to make sure that they can follow the rules of engagement and make proper disbursements to them without jeopardizing your loved one's government benefits. There's special rules that apply there. I'm not going to get into the special rules here today. There's a whole booklet on it with the Social Security Administration, what the trustee can give to them from the special needs trust and what they cannot give them. And the rules recently changed on that as well, okay? So you got to be careful around that. And then also, if you have, number 4, if you have a special needs loved one, you may want to consider, if they have a fairly severe disability, you may want to consider obtaining formal guardianship and conservatorship over them at the probate court. That way, when they attain the age of 18, in the eyes of the law, you no longer have a say over their medical or financial affairs unless you get appointed as conservator to manage their financial affairs and guardian to manage their medical affairs. And you want to get that in advance so you have that paperwork, right in your front pocket if anyone ever calls you on that and say, well, I can't share any medical information with you, mom and dad, because your child, little Johnny or Mary, they're 19 years of age now. They're no longer a minor, they're an adult, and I cannot give you any information. I've talked to folks that were put in that very unfortunate situation. Now they're rushing to the probate court trying to get legal guardianship or conservatorship. Get that in advance. Number 5, become their representative payee at Social Security office. If they receive an SSI, supplemental security income, and some other government benefits, you want to make sure you're the designated representative payee at Social Security so you can assist manage their Social Security monies coming in for them. Okay, really important to do that. I talked to a lot of folks, today in a big family meeting. They're not the representative payee for their loved one. Recommend contact Social Security, become designated, appointed as a representative payee as soon as possible. Folks, there you have it. 5 key elements, 5 key strategies that you should have in play today if you have a special needs loved one. Folks, rewind the video, watch it again, take some notes. If you found this helpful, please share it with other folks that you think would benefit as well. And be sure to subscribe to our YouTube channel. Click the notification bell because we'll continue to keep you updated. If you'd like to learn more, pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Folks, God bless. Take care of yourself. Thanks for being with us today. We'll see you next time at elderlawcare.com.